Well, good morning. To introduce our speaker, a 1989 graduate of Georgetown University Law Center, our speaker, Francine Ward, is an intellectual property and estate planning attorney admitted to practice in California, New York, and the District of Columbia. Her intellectual property practice focuses on helping clients assess and develop their valuable IT. She also helps them on best and most effective ways to achieve copyright protection, and she educates her clients as to what can be protected by the trademark, and she teaches us, because I'm one of her clients, how to defend those valuable rights. Authors hire Francine to counsel them on the intricacies of the publishing process, of which there are many, and it often involves negotiating book contracts. For her clients with websites, Francine educates them on the importance of well-crafted terms of use and privacy policies. Francine's trust and estate practice, which she'll be talking about to us today, focuses on customizing estate planning documents that meet her clients' specific needs, and that could include special needs planning and pet trusts. She is active in her profession, her community, and her church, and Francine also teaches intellectual property law and contract drafting at the California Desert Academy of Law in Indio, California. So, Breakfast Clubbers, please help me welcome my friend, my attorney, and our speaker, Francine Ward. Yay!
Thank you, Susan. And thank you, Antonio, for the invitation. So I am timing myself, and also Tony, if you just as a backup, if you could let me know when I have 10 minutes, but I'm also timing me. So first I want to say that, I am an early riser. I get up at 5 o'clock every morning, sometimes earlier, but honestly, I am rarely camera ready at 7 a.m. And this morning, I was in this call with 6 men, maybe 5 men, at 10 minutes to 7, camera ready. So unbelievable. And the women just kept trickling in. So now I understand why, because you guys were getting your makeup on. I had to already be camera ready. Happy birthday, Betty. Yes. So first I want to say that what I will tell you today, there is no attorney-client relationship that I am establishing. What I'm providing today is useful information, and I hope that it is useful. I'm assuming that it will be, but it's information for educational purposes only. No client relationship is being established today. The other thing is, with 30 minutes, I was thinking, what would be the best way to craft this program? And I thought, okay, I'm going to come up with I think I've got about 9 or 10 common mistakes. Obviously, there's not a lot of time to delve into them in great detail, but I wanted to mention them because while most of you may not fall into the category of making some of these mistakes, I would imagine that at least one of them might apply to you. So I really hope that you just kind of pay attention, and if the shoe fits, then it's some useful information. You can take it back to your estate planning attorney and maybe have a conversation or with your tax lawyer. And if you don't have an estate planning attorney, I'd be happy to offer a complimentary consult to anyone who's interested in this meeting today. So I am going to have a PowerPoint open because and you are free to take screenshots, although it's going to be recorded anyway. So you'll be able to go back and take a look. So first, let me share my screen, and I am going to start the slideshow. So the first mistake, and some of you may be thinking, this definitely doesn't apply to me. Maybe not, maybe it does. But the first mistake, and honestly, this is the one that more than any other, I find it occurs with my clients in particular, not having an estate plan. Now, some of you may think, well, I'm smart. I know what to do. Well, there are a lot of very smart, very famous, very rich people who have died without estate plans. And this is just a handful of them. Johnny Bono, who was an entertainer, and he was a congressman down here in the area where I am. I'm in Southern California, in the desert. Stieg Larsson, an author, a Swedish author. Some of you may have read many of his best-selling books. Among them, The Girl with the Dragon Tattoo. The guy died without any kind of estate plan. Howard Hughes. Some of you may be thinking, well, he was eccentric anyway. But you know what? He may have been eccentric, but the guy was smart. And he didn't become a billionaire by being stupid. But yet, he didn't have an estate plan. Aretha Franklin, another super successful artist, and she died without an estate plan. Pablo Picasso, very often artists become super successful after they pass away. But in the case of Pablo Picasso, he was a very wealthy man before he passed away and still died without an estate plan, as did Steve McNair, an NFL player. So what are some of the reasons that people actually don't have an estate plan? Well, there are many. Number one, people don't necessarily think about it, which is beyond me in this day and age, but they just don't think about it. Number two, they might not have advisors that actually suggest to them that this is something that's important. Cost becomes an issue for a lot of people. They think, well, I can't afford it. But not all lawyers are created equal. Some lawyers are more expensive than others. There are lots of organizations that provide low-cost estate plans. So cost should never be a reason not to have an estate plan. Thinking that they don't have assets. I've had people come to me and they've said, Francine, I don't really need to have an estate plan because I have nothing. Well, maybe not. Other people say, well, I don't have children, so why do I need to have an estate plan? And believe it or not, one of the primary reasons that I have found people do not have an estate plan is because it makes them think of dying. And many people just don't want to have the conversation, even in their brain, that they may pass away anytime soon. I will tell you, as a result of COVID last year, many more people are actually taking the leap and getting documents prepared. So even if you do not have documents, even if you choose not to prepare them, the state prepares them for you, and that is the last thing you want. We call that intestate. So if you, for example, pass away and you don't have a spouse and you don't have children, your assets will likely go to your siblings. And what if you hate your siblings? What if you hate your kids and you have no spouse, but your assets go to your kids? So you have no control over what happens when you don't have documents. Loss of healthcare choices if you become incapacitated. One of the things that's so important is having an advanced healthcare directive, especially today with the sickness and so many people passing away. But if you don't have documents like that, then you give up the control. And again, someone who you might not even want to step into your shoes and make decisions on your behalf, in fact, would do it. So mistake number two is having an estate plan, but not knowing what's in it. Now, I'm sure that does not apply to anyone here, but I cannot tell you how often people have come to me to update their plan and they didn't have a clue what was in the original plan. So what I do as a lawyer, I make sure, number one, I usually do about 3 different edits to make sure that the client knows exactly what's in those documents. Because if you don't, then it becomes problematic for you and your beneficiaries on the other side. So making sure you know what's in your document, making sure that you understand the tax implications, making sure that you understand who your beneficiaries are and exactly what they're getting, making sure if you want them to have a bond or not have a bond attached to whoever your fiduciaries are, but you want to know what's in that plan. Not all plans are created equal. Mistake number 3, having an incomplete plan. So an incomplete plan basically is where people will think that the only important document is the will, or they may think that the only important document is the trust. And so they might not necessarily understand the importance of having more than just a will or more than just a trust. Sometimes cost becomes an issue because definitely if you have, let's say, 5 or 10 additional documents as part of the plan, it's going to cost more than if you just have a will or if you just have a trust. The other reason that sometimes people have incomplete plans is because they have inexperienced legal counsel that really doesn't understand what actually should go into the entire package. You know, when someone comes to me, I've often had people come to me and they'll initially say, Francine, I need a trust if they live in California. And once I start having a conversation with them and I understand all the assets they have, and they have children and they have other family members, then it becomes really to their advantage to extend that plan. And here are some of the things that go into the plan. So there are two types of estate plans. There's a trust-based estate plan and there's a will-based estate plan. The trust-based estate plan, at a minimum, usually when I'm preparing these, there are about 10 documents, sometimes 11. It depends on how many properties a client may have. But generally, at a minimum, a trust-based estate plan includes the trust, and everything is centered around the trust. An assignment of assets. If you live in California, and I know some of you don't, but most of you are in California, if you live in California and you have property, whether you own a house, whether you have brokerage account, whether you have other properties, whether you have expensive jewelry, expensive pieces of artwork or antiques, it is to your advantage to have a trust. Why? Number one, a trust as opposed to a will is a private document. Will, going through probate, and I think Craig had mentioned that he had attended several probate proceedings. Probate is a public proceeding. So what happens in that proceeding is open to the public. Whereas a trust, if it's properly prepared and all of the assets are titled properly, which we'll also touch on, nobody gets to know about it. Nobody gets to know what's in it unless you disclose that information. So the trust, the assignment of assets, and by the way, in order for a trust to be valid, it has to be funded. And in order for it to be funded, the assets need to be titled, properly titled into the trust. That starts with the assignment of assets. In some cases, when real property is concerned, then we also have to have deeds and recording documents. But it's the trust, it's the assignment of assets, a pour-over will. When there's a trust-based estate plan, think of a pour-over will as a cup and a saucer. So if the cup has too much fluid in it, it pours over into the saucer. That's what the pour-over will does with the trust. In the event something is missing or is left out, whether intentionally, well, it wouldn't be intentional. If something is accidentally left out of the trust, the will catches it, and it can then go into the trust, but it will go into the trust through probate. So that's why it's really important to make sure items are properly titled. Then you have the power of attorney for finance. Generally, it's a durable power. You have the healthcare directive, the advanced healthcare directive. You have the Hipaa authorization. Hipaa authorization is really important. And well, we're going to talk about the healthcare directive a little bit more, but the Hipaa authorization is what, in fact, gives your agent for healthcare permission to access your medical records. Otherwise, it makes it really, really difficult for them to do that. And then you've got the deed and the recording documents. Each county has separate documents that are required for recording. For example, down here in Riverside County, we have some different documents that are required as opposed to Marin. But at a minimum, this is what goes into a trust-based estate plan. A will-based estate plan is power of attorney, healthcare directive, Hipaa, and the deed and recording documents at a minimum. Very often what I do also with a trust-based estate plan, I may include a certification of trust, because oftentimes clients, some financial institution will need to see the trust. I almost always recommend that a client never, ever, ever give their trust out except to people with a need to know. If a financial institution needs to see that document, they should see the certificate of trust, not the entire trust. Again, it's a private document. Mistake number 4, having a stale plan. So what's a stale plan? A plan that could be 20 years, 10 years, 5 years, even 4 years. Because in the last 4 years, we have a new administration. There are conversations now about updating tax laws. When you relocate, you should consider updating your documents. When you purchase a new piece of, a new asset, whether it's a piece of real estate, whether it's, again, an expensive piece of jewelry or an antique or a piece of artwork, you should consider updating your documents. When you have kids, when you have grandkids, especially if you want to leave something to them, you want to consider. Is somebody talking to me? I'm hearing something. Okay, I've heard something. Another time you want to consider updating your documents is when you become estranged from your children. Again, not all parents get along with their kids. And if there's some point in time when maybe your kids aren't talking to you, you decide, I don't want them in the will. That might be a time to update your documents. Another time is when you've got children or grandkids who have some sort of mental health issue, maybe substance abuse, maybe gambling. Kids marry someone that you're not fond of, and there's a potential for divorce there. Well, you don't want the other party to have access to your assets. That might be a time to update your documents. When a loved one becomes disabled, when you get married and potentially, especially as we get older, you might get married and form a blended family. That would be another opportunity to update your documents, because you'd want to make sure that not only your kids are protected, but potentially you might want to leave something to the other side. When you get divorced, a lot of times people forget they get divorced and they forget to change those documents. That spouse is still going to gain access to whatever you've initially given them as the beneficiary. When your spouse passes away, I just went through this. My husband just died. I had to update my own documents. And when the laws change, and again, we are at a time right now, nobody actually knows what's going to happen with the law, but tax laws are in the process of potentially being changed. Mistake number 5, not exercising care in choosing your fiduciaries. Your fiduciaries are your trustee, your executor, the executor of your will, the agent for healthcare, the agent for your durable power of attorney. First, I would even suggest that some people don't even have fiduciaries, especially if there's a trust. You might make yourself the initial trustee, but do you have a successor? Do you have a second successor? Do you have another successor in the event something happens? How do you choose those fiduciaries? Do you actually take good care in making the selection? Sometimes people do, and sometimes people don't. A couple of years ago, I had a client, and it's not the first time I had a client like this. It was a husband and wife. They were elderly. They had 2 daughters. One of their daughters was super responsible. She was, VP at a bank. She was really smart and very responsible. The other daughter had a substance abuse problem. But the parents didn't want to alienate the daughter with a substance abuse problem. They didn't want her to feel bad. And so what they did, they made them co-trustees. Bad move. And eventually, unfortunately, it came to pass that it was a big, big mistake. They ended up having to change their documents. Are the people that you choose or you've chosen initially, are they still the appropriate fiduciary? Let's say, for example, you created a trust 10 years ago. Perhaps the person or the persons you selected are dead. Perhaps they've become ill. Maybe they have become too old in a sense to actually be as responsible as you'd like them to be. Could be a number of issues. Again, that's something to think about. Are they still the appropriate fiduciaries for your estate plan? Are those fiduciaries aware of the nomination that you've made? Are they aware that you've actually selected them to step into this position? Maybe, maybe not. It's important that they know. Believe it or not, a lot of people don't tell them. When I do my first draft for a client, we literally go over the entire document. And then I encourage them to talk to their fiduciaries. Let them know exactly what's in this document and what's expected of them, what kind of powers they will have, what they're allowed to do and what they can't do. That's really important, because you may choose someone that says, you know what, that's a big responsibility. I don't think I can handle that, but thank you for asking me. And then you'll have to consider someone else. The other thing is you might want to consider having a trust protector. That's the person that then oversees the person who's the trustee, for example, especially if that trustee is not someone who you think is totally responsible. Mistake number 6. Do your fiduciaries have access to your passwords? Now, honestly, this is something that just goes over most people's heads. Why? Because today, many of us actually have our passwords maybe in a safety deposit box or online, but how many people actually know how to access those passwords? Well, if it's your fiduciary, they should at least know where to go to get access. Very, very important. Mistake number 7, failure to properly title trust assets. Again, as I said, in order for a trust to be valid, the trust has to be funded. And in order for it to be funded, all of the assets within that trust have to be properly titled. The mistake generally occurs at the very beginning of creation. So when I'm preparing a document for clients, I generally will include the primary residence as part of what I've charged them. So I will take care of the deeds and the recording documents for that document, for that piece of real estate. But then I also prepare a memo, a funding memo that I give to them at the end, and we go through it, educating them on how to actually retitle or title any new assets or existing assets. So initially, when you have the plan, it's really important to understand how to title your assets. Whenever you update your plan, especially if you're amending and restating your trust, it's important to make sure that your house, whatever you have in the trust, your brokerage accounts, if you've got a retirement account that you want to have titles, you want the trust to own, you want to make sure that your wealth manager understands that and that everything is properly titled. A big, big red flag is refinancing. So when you refinance a house, the financial institution must take your home out of the trust. That's what they have to do in order to refinance. Rarely do they put it back in, and you would never know. And so what you need to do is make sure when you refinance that they put it back in to the trust. And if they don't, you need to make sure that you put your house back into the trust. It happens all the time with refinancing. I've seen it over and over and over again. When a client comes to me and I'm updating a document or updating all of their documents, and then I have to check the deed, and I always check the deeds myself, I discover that the deed is not in the name of the trust. Even though the client thinks it is, it might have been in the name in the trust before, but once it was taken out, it was never put back in. Big red flag. Again, if your home is the primary asset that's funding your trust, if you have a trust, you want to make sure that the home is in the name of the trust and not in your name as an individual. Also, any new purchases, whether it's real estate or you open up new brokerage accounts or you purchased, sometimes you might even have the life insurance in the name of the trust. Whatever it is, if the trust is being funded with an asset, you want to make sure that the asset is properly titled. Consequences of not doing it, the asset is not in the trust, and therefore, the very thing that you wanted the trust to do, and that is be private and protect your assets, your beneficiary, or rather your trustee or your executor, is going to end up having to go to court to prove that, in fact, the house was supposed to be, or the asset generally was supposed to be in the trust. Mistake number 8, not making allowances for pets. Now, I'm an animal worshiper, forget lover. I have 3 cats. Honestly, I absolutely have a pet trust, because if something happens to me, I want my cats to be taken care of. I know some of you have animals that you absolutely adore. Here, there are people in the desert that have horses, they have cats, they have dogs, they have bunnies, they have all kinds of animals. If you love your animals, you want to make sure that they're protected. So making sure that if you have a trust, You might consider having a sub-trust, which would be a pet trust within your trust, or it could be a separate document. Think about who's going to care for your animals, someone that you trust. Then you might want to consider, is there going to be a caretaker who's going to do the day-to-day caretaking? So the trustee might be the one who oversees it all. The caretaker might be the one who handles the day-to-day affairs, taking care of your animals. Have you secured their permission? I had a client once who came to me. They wanted to create a pet trust, and they had nominated someone to be the trustee. Well, this person ultimately, because I do due diligence before we finalize anything, this person didn't want to be the trustee. They didn't want to take care of those animals. They were dogs. They just didn't want the responsibility. Making sure you secure permission before you nominate someone. The other thing is, have you left sufficient funds or generally resources so that your animals can be cared for? You may nominate someone, you may say, I want you to take care of the animals, not really have talked to them, or maybe you did speak to them, but you haven't left them enough money to actually handle the medical, the food, the care and feeding of your animals. Again, just things to think about, making allowances for your pet. Mistake number 9, improperly leaving assets to special needs beneficiaries. Now, this is a problem that I've seen a lot of late. So this shows up if you have disabled children, disabled grandchildren, a disabled spouse. Usually it's children, grandchildren. You have siblings that are disabled, or you have loved ones, just generally loved ones. It could be friends. And out of the goodness of your heart, you want to leave something to them in your estate documents. So you decide to make them a beneficiary, or you make them a designated beneficiary of a life insurance policy or on one of your brokerage accounts. Well, without knowing what you're doing, you have just set them up for trouble. Because if that's a disabled party that's receiving any kind of government funds, Medicare, Medi-Cal, Social Security, disability insurance, any kind of government funds, you potentially have then made it so their government funds will be disallowed because you have now made them a specific beneficiary with a specific distribution. So you want to be really careful. If you're going to leave something to someone that you love who's disabled, make sure the documents are prepared in such a way that you don't prevent them from getting the government help that they need. And then the last mistake that I'll touch on is not fully utilizing your advanced healthcare directive. So very often people think that a healthcare directive is just about a DNR, a do not resuscitate. And if that's all it was, then you don't even need to have a document for that. Your doctor can do it. They can do it in the hospital. But a fully utilized advanced healthcare directive should speak to everything that you want with regard to your healthcare. It should not only speak to your whether you want to be resuscitated, it should also speak to how you want your body to be treated. Do you want to be cremated? Do you want to be buried? Where do you want to be buried? How do you want to be treated afterward? Do you want your organs to be donated somewhere? Do you want your organs donated only for certain things? Maybe only for research, only for education. You get to specify that the more fully robust your advanced healthcare directive is. Also, what I do in my directives, I not only prepare a Hipaa authorization form, which gives a medical provider the authority to provide your medical records to your agent, I also include that in the healthcare directive. So not utilizing this document, really, it becomes a waste of the document. Anyway, I think with 2 minutes left, and I am happy to stay on for about 15 minutes if you have questions, I think I will end it there. Again, I will just say this. It is critical, especially as I look at this group. Now, I'm 68. Some of you look younger than me, some of you maybe not, but at this age, it is critical that we protect ourselves. If you have worked your life for anything, if you own a house, if you own anything, if you have kids, if you have grandkids, you want to make sure that your beneficiaries are protected. You want to make sure that you get to decide what happens to your assets, not the government, not California, if you're living in California, not some other state. You want to make the decision as to what happens, not only to your assets, but what happens to your body, what happens to your body and your finances. With that, I want to say again, thank you so much. With 1 minute and 42 seconds to go, I'll stay on for about 15 minutes, 20 minutes, however many questions you may have. Thank you. Phew, I got that out.
Francine.
I wanted to get all of those out. Whew.
That was a lot.
Thank you.
I
Thank you.
tried.
That was fantastic.
Amazing,
Wow.
Francine. Thank you.
Why don't we start off some questions with Susan Rowan, since she introduced you?
Well, I would say this, I have just done my trust and now I have more questions. So thank you, Francine. And I have already decided years ago, my body's going up to UCSF to be researched. And what I expect is all the doctors around my body going, oh my God, we have to find out how anyone could be this gorgeous, this long, and not have a facelift. So that's what my plan is for my afterlife.
You know,
Any other questions? I'm looking in the chat, if there are questions in the chat.
I'm in the
Oh,
process
so
of
one
updating
question-
mine too. So you know, it brings out so many questions because you have to think through all these things. Yeah, I
Yeah,
really
they're important
appreciate what you're.
documents. They do require thought. You know, a lot of times people will go to trust mills or they'll download something off the internet and think that's sufficient. But these things require thought because this is you. This involves you, your assets, things you've worked very hard for all of your life. Why would you just why would you not want to treat it with care? Yeah. I see a hand up, Betty, and then I see some questions in the chat. Betty?
Thank you for a great presentation. I had a trust probably 40 years ago started, and I finally finished it. It was there, but not up to date. So I finally got it done, but you're my next trust person when my trust person retires. Couple quick questions. You say fund the trust. What do you mean exactly? Just because you put something in it, is that funding it? That's one question.
So it's two steps. Let me answer one at a time, if it's okay with you.
Please.
So two-step process. Number one is the assignment of assets. That is the document that says that you actually want these assets to go into the trust. That's number one. But with some documents or with some assets, you then need to retitle them like your real estate. The deed has to be retitled and it has to be recorded with the county. With your brokerage accounts, you need to make sure that your wealth manager understands that it's going to be in the name of the trust. That's how you retitle. That's how you fund the trust. Also, you might have a bank account that is just a trust account in the name of the trust. So that's how you fund it. Two-step process.
Okay. And then the second question, yeah, how do you determine how much you're going to pay your fiduciary, your who's going to oversee everything for you?
So in California, there is a statutory amount that someone can get, but you can decide. I mean, you can do anything you want. It's your trust. So you can put in the trust a certain amount that you want them to be paid. It could be a percentage, but the state, if you put nothing in, the state actually has a percentage. And whoever, you know, we don't know what it's going to be at that time, but you can make a decision. You can say a dollar amount or a percentage of your assets.
Okay, thank you.
One more thing about that, sometimes trustees will waive the right to receive compensation. That's a choice, and you can even include that in the trust where the trustee has the right to waive receiving anything. Because they may have the money, they don't need, they don't need your money. Other questions? I see Paul. Was that it, Betty?
Francine.
Let me first make sure. Betty, okay. Yes, Paul.
Good morning, Francine. That was a very, very entertaining and informative talk you gave us. I must confess, of course, being a British person living in a British overseas territory, it's not wholly, well, the principles are the same of my understanding of trust. But I saw in one of the slides, but I apologize if I missed it in your wording, but there was a reference to the protector. Could you just explain the role of the protector, please?
Yes, it's called a trust protector. So, and it's not always something you would do, but let's suppose that you have a trustee and you've chosen this trustee. Maybe it's one of your kids. The kid's not super responsible, but you wanted to have your kid there so they wouldn't feel bad. You might then choose another person who is really responsible in the event your child or that initial trustee doesn't do what they're supposed to do. The trust protector is overseeing and they can step in. So it's just like someone who's overseeing. In fact, I just did that with my own documents when I redid them. I have a corporate trustee, and I have chosen someone to oversee to be my trust protector. So it's just another layer of protection, making sure that your desires and needs and wants are actually carried out in the way you want them to be carried out. Did that answer your question, Paul?
I have a question.
Yes, it does. As I understand it, just ever so quickly, but then is it if in the unlikely event that the trustee is acting improperly or just not with due care, that the protector can come? I mean, who carries the power on this? Does it end up in the courts
Well,
if
it depends.
It's a real problem?
So it depends. That's the power of a trust. You get to set the parameters. You know, trusts are not one size fits all. They just aren't. So when you're drafting a trust, you can decide if you want the trust protector to have the final say. Ultimately, if there's an issue there and you don't give the trust protector the power, it can go to court. And you can make that decision too. Or you can decide that the beneficiaries have the right to oust the trustees. I mean, there are lots of things that can be done. Again, it's not one size fits all. But if you want the court to make the decision, they can do that. But that becomes costly.
I was going to say that might be the least attractive option. But anyway, that response, Francine, extremely helpful. Thank you very much.
I see we have Sydney's hands up and also Richard Chen.
Okay. Thank you.
Sid? Oh, Sid, your mic is on.
Francine, I have a question. In a special needs trust, what do you recommend to make sure that your beneficiary is not disqualified from receiving outside benefits?
Well, that's exactly what I was saying. You want to make sure that whoever's drafting that special needs trust, make sure that they don't disqualify your beneficiary from receiving the government funds like Medicaid, Medi-Cal, SSDI. But that's why you want to really make sure it is important, and that's a niche area these days. It's a hot area because so many people are being disabled for whatever the reason. So yeah, you want to just make sure. The trust has to be drafted carefully. Sometimes they can, you may choose to have a separate special needs trust, and sometimes it could be a sub-trust within your existing trust. But the language has to be really fine-tuned to make sure that there is no interference with your disabled child or grandchild or other loved one, that they're not disqualified from receiving government funds.
Well, what is the language?
It's not one size fits all. Well, there's no one size fits all, so I can't tell. And I'm not your lawyer, as I said early on. I'm not establishing an attorney-client relationship on this call. And again, it's not one size fits all. It depends on who you're talking about. It depends on you. It depends on a number of factors. So if you'd like to have a conversation, I'm happy. Again, I'm happy. If you don't have your own estate planning lawyer, I'm happy to offer complimentary consult. But I can't give you that information here. Yeah. Because I don't know the facts, mostly. I don't know the facts of your situation.
Sydney,
Hello.
Sydney, you're up next. And then
Can you hear me
Richard
now?
Chen. Yeah, we can hear you.
Yes.
Thank you. Francine, I see your name, Francine, but I don't see your last name. You're not on the screen.
Oh.
Yeah.
Ah.
Uh-huh.
Well,
So-
it's Ward. I'm putting it up right now.
What?
There you go.
Wait a minute.
There it is. There it is.
Where
I
are
just,
you?
well, I see me.
You see me?
I just-
Okay. Francine, is
I
it
see
Ward?
me. And I see you.
W-A-R-D or what?
Sydney, I'll
Yes,
connect
sir.
you guys. I'll do an email introduction for you.
Okay.
All right. And Sid, did you have any questions, or we're just confirming Francine's contact information? Okay, we don't know.
And
if
again,
anyone,
I'm very,
Yeah.
I want to say again, I'm very happy if you don't have an existing estate planning lawyer. And again, if you don't have one, I am happy to offer a complimentary consult to anyone to talk about something specific to you. But again, in this venue, there's no attorney-client relationship being established. I need to make sure that's clear. So there's no legal advice I can offer you here, just general information. I see
Yeah.
Patricia's hand up.
oh,
And
don't
I
forget
see
Richard.
Richard.
Don't forget Richard. Also,
Richard,
All right.
Richard, I see Richard first. Yeah, Richard.
All right.
Yes, Richard.
Yeah, thank you very much, Francine, for the presentation. I really enjoyed it and stuff. I have to remember to give out the passwords of fiduciaries yet. I haven't done that yet. but I have two questions, or one if you don't have time. But first question, like, I mean, the trust is more of a private document. Why would anybody do a will? I mean, it's public. Why would anybody do a will?
Well, the will, if there's a trust-based estate plan, there needs to be a will because, and it's called a pour-over will if there's a trust-based estate plan, because what if you forget to put something in the trust by mistake? You want to make sure it's still captured. So, yeah. But if you don't have a trust, then you'll just have a will.
But because you had a
why
difference between trust-based planning versus will-based planning. So why would anybody do a will-based planning if it's all public? That's it.
Because some people don't care. They're also cheaper. And also,
Oh.
if you don't feel like you have assets, like if you live in California, honestly, and you own a home, you need to have a trust, period. Because probate in California is horrible. There are other states where probate is not as onerous, like New York. I'm admitted to the New York bar. It's easy. In New York, we mostly do wills. But here in California, it just, number one, it's easier to have a trust, but it's also a private document. Some people don't care whether it's private.
Okay.
But if you do care, then it definitely should be a trust. Plus, if you have property.
And
You had another question, Richard?
Yeah, one last question was like, so you mentioned in terms like if you move from one state to another state, like if you had created trust in one state and you go to another state, like to California, from Massachusetts to California, the original the state, the trust where the state the trust establishment, do the rules change, or how does that work? Does that I mean, that might be a
It
tough question.
depends.
Yeah.
So it depends. California will honor other documents from other states generally, but you should have a conversation with a lawyer just to make sure.
Yeah.
And to make sure, like if you, again, it's the retitling of your assets. So if you move from another location and you've got let's say you purchase a house in California, but your documents were formed in Pennsylvania, let's say. If you have a house here, you still need to have the deed recorded here in California, whatever county you're in, if you're San Francisco, Marin, wherever.
Good. Thank you very much.
Just having a conversation with someone.
Thank you.
Patricia, I think was next, or someone else. Oh, yeah.
Yeah, well, hello, Francine. Wonderful to see you
Hi,
again, as always. This was very enlightening. There's a very interesting question in the chat from Tom. Is there a provision in a trust for the assisted suicide law in California?
No, not to my knowledge. I have never included, no.
And Janice
the-
wants
let
to
me
know
look at-
your contact information, which Susan, no doubt you could put that in the chat for Janice and anyone else while Francine is answering questions.
Okay, so I will make a comment. I see Anne made Anne put in a link about Aretha Franklin. So they were 3 handwritten wills and they were found to be invalid. So that brings up another issue about holographic wills. Thank you, Anne, for putting that in. So a holographic will is a will that is handwritten, but all of the pertinent, important terms, all the relevant terms have to be in the handwriting of the testator. That was not found to be the case with Aretha Franklin. So her kids have been dragging this through court because even though she made an attempt to have a holographic will, all of the important provisions were not in her handwriting. So, you know, again, it's never as cut and dry as people sometimes think. It's never black and white. Which is why many of these cases are in court forever and ever and ever. I mean, forever. Jimi Hendrix, his estate just dragged his case through the courts, I think, for the last 10, 15 years. So, you know, to avoid that, to avoid your beneficiaries and your fiduciaries from having to live in court and spend all of your money on court fees, take care of the documents while you're alive, while you're competent. See, there's another question. Let's see. Is there a minimum amount of assets you need to have to a trust? Not really. But again, I mean, the trust needs to be properly funded. So if you have a house, your house should definitely be in the trust. If you don't own a house, then if you've got some money in the bank, I mean, there's no minimum amount, but there should be a sizable amount where it's really, if it was challenged, it could really be demonstrated that it's funded. Also, you'd have to have trust administration fees. So you want to make sure whatever's in the trust can cover those fees, that your trustee doesn't have to go into his or her pocket to take care of your expenses. I'm looking to see what else is in the chat. Is there a provision for the assisted living? Yeah, I don't put one in, but yeah, but it potentially could be, but I don't put one in. How can you reach you? I will, Antonio, you can feel free to send out my, okay.
I just did.
Let's see. Okay, and I'm looking to see if, and Anastasia says, I especially said to know about how you might add a complication to a disabled beneficiary. Yes. Again, you know, the special needs planning is so important today because more and more people are being considered disabled, whether it's because of a mental health condition or something. So it's really important how you handle that. You do not want your loved one to have their government funds removed because you love them so much that you've left them all this money, that you've put their name, you know, as a designated beneficiary on your life insurance policy. And are there other questions that I am missing here?
I think
Anybody else have a hand?
Patricia had her hand up, and I see Ann has her hand up also.
Okay. Mm-hmm.
Well, go to Anne, because I asked and Anne's been helpful feeding you information.
Yeah. Ann Mahoney.
That's okay. Ann Mahoney, handwriting and forgery expert. I'm going to hold up a document. I don't expect you to see it. Maybe I'll put it back here, but these are all witnesses. This is the case I'm working on now, and they're all forged. All the signatures are forged, the witnesses, everything. I wanted to make a couple recommendations, Francine, and you can certainly comment. For your witnesses, have them at least 10 to 15 years younger than you are. You want them around when you're gone. Have their address and contact information, and hopefully there's someone like a broker or a doctor or someone so we can find them. Many times we can't find the witnesses because the attorney just says, Joanne, can you come in here and witness this? And we get a scribble and her name is Joanne Smith. She gets married 2 years later. She moves. We don't know where she is. So make sure your witnesses are younger and traceable. The other thing, now, Francine, you're not going to be happy with this, but sign every page of your will. Sign.
Oh, I do that. I do that.
Sign every page of your trust. I've had attorneys say to me, the trust is 80 pages long. I'm not going to have my clients sign every page. Bring them to your office, give them their favorite sandwich and let them sit there and sign, because here's what's happening with family members. They're leaving dad's original good signature on the last page, and they're changing page 15 that says, you know, the house I was in Tahoe, I was going to leave to my son. I think I'm going to leave it to my faithful executor. So the son goes in and goes, that's dad's signature. That's a legitimate will. And other parts have been changed. If you had signed and dated every page, it would have been much more difficult for that person to slip sheet and substitute a page. That's all I'm going to say.
So I want to speak to what Ann just mentioned something. So the only time you would have a witness is for a will. You do not have a witness for any of the other documents. All of the other documents are acknowledged. I have notaries for everything. And with regard to the witness, on the will, I actually agree with you. And what I make sure is I have the name of the witness typed. I have their address, all of their contact information, because we want to make sure they can be found. But I also do that with beneficiaries. I have the name of the trustee, the beneficiaries, their address, because of what you're saying. What happens if you can't find them? But one thing I will say, while I have all of my clients initial every page, I do not have them sign every page, but I have them initial every page. You know, it's a personal choice. Some lawyers don't do anything. That's what I choose to do. I do have them initial every page other than the page they've signed for the same reason. But again, you know, the key is to make sure that in the event these documents are challenged, which you hope they won't be, but if they are challenged, that there's sufficient information that can be used that support whatever it is you want done in those documents. I see, I have about 7 minutes. Claudette, I see you. You hadn't asked a question yet. And Patricia had another question. Yes.
This is a quick question. If in fact you think your witness now was maybe too old and you don't want to redo your will, can you redo the witnessing? Can you have
the whole
another?
thing has to be redone.
Okay.
No, but if you've got, number one, it's really important. This is why choosing wisely who your fiduciaries are and who the witness is. Again, witness is only for a will, only for a will. The rest, you know, you want to make sure the executor, the trustee, the agent, all of those people are people that you've carefully selected, not only because they're responsible, but also age-wise. You know, you want to make sure that they're going to be around, but I have to say, on the other side of that, nothing's promised to any of us. You don't know. I mean, I've known many people who passed away in the last year who are definitely younger than me. So age is necessarily not a factor. Rather, it's a factor, but it's not the primary factor. So, you know, if you have younger people, but again, you want people that are responsible. You don't just want to go grab your grandkid who, you know, who has a gambling problem to be your fiduciary. No, you'd be surprised, but you don't want to. That's not responsible. Patricia, you had another question?
Yes. As someone who has no children, I have younger friends, but it's a lot of work to handle people's issues. I remember when Roanne had to do it. Aren't there professionals that you can hire to and then have your own personal friends oversee it? I really don't want.
That's what I did.
Okay, good.
That's what I did. I just did it when Richard died. You know, my husband passed away. I just redid my own documents. I made the decision to have a corporate, a professional fiduciary, and then I have someone as the trust protector. And actually, the person I have as the trust protector, I have someone. So yes, it's easier. They know what they're doing. There is a fee. And if you're interested in having a corporate trustee, you know, you have to investigate, figure out what they want, you know, how much they want. It's usually a percentage, but in many cases, it's a better thing. If you're in a position to afford it, it's worth it because it's a lot of work for any one person, especially if somebody has a life. So choosing them carefully. Susan?
Well, I was and still am an executor. It was about 10, 11 years ago, and Fripp remembers what I went through. Luckily, she had her documents. I didn't trust her trust attorney and changed, thanks to Sandy Shepard. But the truth is that leaving a percentage, if you're having someone do your trust, you leave the money because it takes a whole lot of work. And the other thing I would suggest is you do have to go over your trust. I had to write $200,000 money orders or whatever to go to Switzerland for cousins who never gave her a glass of water. She never reviewed her trust. So I would say that if you're getting older, have a younger person remind you to do that. I've already assigned the younger person that's going to remind me to see who I cut out of the will.
Oh, I have a question.
I think that's, mhm.
Oh, just, I mean,
Yeah.
we're, the world's
No, no,
getting
go ahead.
smaller. How about when you have assets in different countries?
Then,
That's
if you
interesting.
have assets, even assets in a different state, if I'm dealing with someone like here in the desert, I have clients who live in Canada and they're snowbirds. They have property here in the desert. They live in Oregon. They live in Washington. I bring in local counsel, because I don't know the laws in another country. I don't know Canadian law. I don't even know Washington state law. I mean, I could look it up, but I don't really understand it. So I always bring in local counsel. It's just a smarter way to do it. Yeah.
Good.
It's like I don't do anything other than IP and estate planning, and even my IP, I don't do patents. So I would never hold myself out as a patent lawyer. If somebody comes to me with a patent issue, I bring in a patent lawyer. So it's like I know what I know, but I don't know what I don't know, and I'm smart enough to ask for help.